Children's Amendment Bill 2020, second stage. The question is that the bill be now read a second time. Could I call on Senator Michael McDowell, and Senator, you have 16 minutes between yourself and the seconder. Could I welcome the Minister into the House as well? Thank you, Minister, for being here for this important
I'm going to share my time with Senator Craughwell on the basis agreed between ourselves.
That's grand. Is that agreed? Agreed. Thank you.
I move that this bill be read a second time, and the Children Amendment Bill of 2020 is a bill which emerges in circumstances which may be a little bit of a surprise for a lot of people. The Court of Appeal Civil Division delivered a judgment on the 29th of October last. The court consisted of the President of the Court, Mr Justice Birmingham, Ms Justice Kennedy and Ms Justice Ní Rafferty. And the name of the case was the people at the suit of the Director of Public Prosecutions and EC, and the appeal that they were dealing with was an appeal brought by the Irish Times, Independent News and Media, RTE and the News Group newspapers against an order made initially by Mr Justice Michael White and subsequently by Ms Justice Carmel Stewart in the High Court, directing that the identity of the child, the subject matter of the prosecution in question, who had was the victim of what was an apparent homicide, should not be named or identified, and the circumstances are quite particular to the facts as found in that case. One of which was that in the end the accused person was found not guilty by reason of insanity, but the question of the child being identified as being the alleged victim was the subject matter of the two judicial directions to which I have referred. The matter was appealed to the Court of Civil Appeal by the newspapers in question, and the judgment which was handed down on the 29th of October 2020 in effect rejected their appeal on the grounds that the wording of the Children Act in section 252 of the Children Act and the definition of a child did not exclude a deceased child, the victim of an alleged offence. So of course, it was decided on its narrow facts, but the reasoning of the court had a much wider implication, because by implication it referred to cases where there were convictions to start with, and also to cases where a variety of offences could have occurred, and a variety of circumstances might also have occurred. And in response to that decision, and in particular in response to what was stated by the President of the Court, Mr Justice Birmingham, at paragraph 14 of his decision, this bill was generated by the independent group of senators in this House, to whom I am grateful for their support. Paragraph 14 said, "I appreciate the media may find the ruling surprising, and that they may say that it involves a radical departure from what had been long-established practice. They may say that the outcome is an undesirable one, and may be in a position to make that argument with some force. Nonetheless, the language of the statute is clear and unequivocal, and, enjoying a presumption of constitutionality as it does, must be given effect to. If change is required," and this is a crucial sentence, "if change is required, and if it is desired to return to previous practice where it was possible to report cases involving the deaths of children, then it is a matter for requiring intervention by the Oireachtas." So it's in that context, without challenging at all the correctness of the decision of the Court of Appeal, but bearing in mind its scope, that this bill was tabled before this House. I should also mention that parallel with the independent group's initiative in tabling this amendment in this House, my good friend Deputy Jim O'Callaghan introduced a private member's bill in the other House, Dáil Éireann, to much the same effect. And both he and I discussed between ourselves and subsequently with the Minister, and I welcome the Minister here today to this House. Both he and I discussed together and in subsequent discussions with the Minister and her officials how this situation could best be remedied. And I have to put it on the record that the fact that my bill was chosen was a bit of the luck of the draw. It reflects nothing on Dáil Éireann or Deputy O'Callaghan's bill. It's just to do with what was considered the most expeditious way of dealing with this legislation. Now, obviously, it's a huge injustice to the parents of a child who was killed in a homicide that they can't really, and news media can't really carry coverage of the fact that their child was the subject of a court proceedings for an offence in which a conviction took place, when the public will probably, in most cases, be well aware of the identity of the person convicted. It's a major reduction of the rights of apparent free speech and the rights of parents to tell their story in public and to express their huge tragic loss in many cases and their feelings about what has happened to their child. That the law should have this clearly unintended effect. Now, this House and the other House are intended to presume the consequences of the clear language we use. And it has to be said, going back to the year 2000, when the Children's Bill was enacted, that nobody at that time saw this bill as having this effect. And perhaps that is a signal warning to us all to be extremely careful in parsing and analysing legislation and not rushing things through without very, very careful consideration of precisely what we are doing. And it is the case, of course, that for 19 years after that legislation was passed, nobody actually thought of the dimension which arose in the DPP versus EC case, and nobody thought to suggest that there was a problem in relation to it. Now, so I very, very much welcome the approach being taken by Minister McEntee to this matter, because all of us, everybody on all sides of both houses, I presume, wants to take up the invitation put to them by the President of the Court of Appeal, Mr Justice Birmingham, that if this is not the desired outcome, that it's a matter for the Oireachtas to deal with it. And I very much welcome the open attitude of the Minister in adopting one or other of the two bills, either Deputy O'Callaghan's or my own, and signalling a willingness to do that, and getting on with the process of legislating in this matter. Today is just the second stage. And the Minister's Department has kindly indicated to me that they propose making various amendments to the rather simple formulation which I and my colleagues have put forward as a remedy to this problem. Because there are unforeseen consequences lurking here, whichever way you go. Just to take one example, if, for instance, a sibling who is a child murdered younger siblings, you're left with the situation, can those children be identified in circumstances where the offender, the person who murdered or killed those two children, is himself or herself a child? So there are corners around which we have to look, and I very much welcome the fact that the Department is putting a lot of effort into making sure that in remedying one problem, we don't create another problem and say that a rush to legislate opened up another problem. So I fully recognise the Minister's willingness to consider the matter and to proceed carefully with it. It's not something which is devoid of complexity. I fully concede that. And such amendments as the Minister has outlined through her officials to me seem to me to be ones going in the right direction. But again, I just ask that, that whatever is done, we consider it very, very carefully. The example I just gave is just one example. Personally, I've never been overly attracted to the notion that all child offenders, for all time, and we're talking about 17-year-olds now, it should never be, in any circumstances, permissible to refer to the fact that they were convicted of an offence. And I know that this comes from a long line of law which is to the effect that children are in a special category, that they must be capable of redemption, that their reputations cannot be tainted for all time in respect of a child offence. I accept that, but I also think that there are sometimes practical outworkings of that which cause immense difficulties, and this House will be aware of the difficulties which arose in a similar case in the United Kingdom, where the media did or did not behave well in relation to a particular murder of a child, and all the complexities which followed on from that. So what I want to say at this stage is the principle of this bill is to effectively take up the invitation given to the Houses of the Oireachtas by Mr Justice Birmingham to legislate in the matter if the unexpected and unwanted implications of the judgment in the DPP and EC case are to be readdressed by the legislature. And that's what this bill, that's the principle of it. And therefore, in principle, I think there's all-party backing for the principle of this legislation. It is legislation that I concede will require tweaking this way or that, very careful tweaking and very careful consideration. And although the Minister is under immense pressure to legislate very fast in relation to this, and I have no problem about speed in legislation, it will have to be careful, and these particular matters that I have raised should be addressed. The final thing I just want to say in relation to this is we've had recently, and again I'm going to be very careful in what I say, a case in which a child, legally a child, was the subject of what appears to be a homicide of some kind, subject to defences. And it is strange that the result of Section 252 and the judgment of the Court of Appeal has resulted in the situation that great publicity is given to an event, and then a subsequent criminal prosecution is wholly divorced from that great publicity, and the public are not entitled to know whether there have or have not been prosecutorial consequences for that particular death. So these are the kind of pressures that we're under, but we have to get this right. And in those circumstances, I commend this bill to the House. I thank the Minister for the generous approach she has adopted. I thank Deputy O'Callaghan for his generosity in his discussions with me on the matter. And I therefore have pleasure in moving this matter through second stage and looking forward to a detailed committee stage amendment session on this bill to make sure that it is right and it doesn't do anything that none of us wish to be the consequence.
Thank you, Senator McDougall. I understand